All right, and the topic of today's class is really kind of, as you were saying, self-contained for sure, but also short on the short side, because the material we can cover pretty quickly. It's women and inheritance. Women and the laws of inheritance.
Well, I may have some questions about that.
Oh, good. I may not know the answer to all of them, but I'll do my best. Okay, so first of all, I want to just take a step back before we get into that specific topic and talk about women and contracts, women and the law in general. This is a topic that seems to be a sore spot for a lot of women sometimes when it comes to Jewish law, because it seems that women are given the short shrift, given the short end of the stick. They seem to be disadvantaged, it seems, and we're going to get into that when we talk about inheritance. But just so you understand, according to Jewish law, women have the same legal standing as men. The same legal standing. So what does that mean?
With regard to inheritance.
No, I'm talking generally speaking. So financially, for example, a woman has the same rights as a man. What is the Talmud actually explains this. It actually is very specific about what that means. And quote, the Torah verse, now the Gemara is going to be now quoting Torah verses and explaining them as a way of, you need some paper.
No, I thought I had something with
Here.
me that I don't.
Oh, do you want a pen?
Oh, I've got a pen.
You want some paper? I have paper.
Okay. Yeah, I had a spiral notebook and I left it at home.
Oh, okay. So I'll borrow your pen. No. Okay.
So the Gemara is now going to be quoting verses from the Torah in a way, as a way of explaining how women are absolutely equal under the law when it comes to Jewish law. So here, quote, Gemara, quote, the verse, if either man or woman will commit any crime, that is the Torah verse, if either man or woman will commit any crime. So now the Gemara comments on this verse. This teaches that the Torah equated men and women with respect to all culpable acts. Right? So a man commits a crime, a woman commits a crime, they're equally culpable under the law and have to be brought to law. Yes?
But I thought because mitzvot are different, in some cases different for men and women, that can't be equal under the law.
Okay, so...
And also, isn't it true that women are more punished if there's adultery or something?
Okay, first, let me answer your first question first. Women have fewer positive commandments than men. Women are equally responsible for negative commandments. Crimes would fall under the category of negative commandments, what you shall not do. So, for example, murder, you shall not murder, applies equally both to men and women. Therefore, if we're talking about committing a crime or a sin, which is the same thing in Torah, right, then the woman is equally culpable. Okay, and so when it comes to Jewish law, again, so if you're talking about, let's say, the other side of that would be, again, I don't know if there's a culpability issue with a positive commandment that's time related that you could be brought to court for. I think I'm pretty safe in saying that any Torah crime that you could be brought to a court of justice for would be something that men and women would both equally be culpable to. Because again, the commandments that women are exempted from, and of course it's not banned from, but exempted from, are time related, and most of them are prayer related, right? So minyan, tefillin, right? Davening 3 times a day, right? They're not obligated for 3 times. Those things are not. I don't think that any of them would have any. I don't think that you'd have a court case regarding such a halacha. Right? Okay, so that's not really an issue. The second thing you said was, remind me?
I thought if a man has a child out of wedlock, that's not as bad as a woman having a child out of wedlock. Or if they're married, she's more punished than him. Am I wrong?
Well, it depends. It depends on the situation. If we're talking about premarital sex or extramarital sex, meaning that it is nothing that let's say neither party is married, then it's not adultery. It's a different case, and it's not a capital crime either. It's to begin with, it's not a capital crime, right? The only time it's an issue, is a real serious issue, is if either of the parties is married, right? Then it becomes adultery, right? For both, if both parties are married, it's an equally serious thing. The child from such a union is not, there's not a special punishment that the adulterer gets if they have a child. It's the act of adultery itself that makes that the crime. Okay.
Thank you. Sorry.
Yeah, sure, no problem. Okay, so that's men and women under the law in terms of committing crimes, in terms of committing sins that are actionable. All right, many sins are not actionable, right? If I do something in my house and nobody knows about, only God will act upon that. I don't get brought to a court of law for every sin that I commit. Okay. The Gemara continues speaking. The verse, "and these are the financial laws that you shall place before them," teaches that the Torah equated men and women with respect to all financial laws. So, again, the verse from the Torah is, "and these are the financial laws that you shall place before them." And again, I guess the Gemara is picking on the word "them," and with the supposition that "them" refers to male and female. Okay, so that men and women are now equal under the law, under all financial laws. So in other words, what this means is a woman can enter into a contract, any contract she wants. There's no limit. It's by the way, that's a very different thing from secular law until recently. A woman was not able to enter into a contract by herself without her father or her husband, sort of being the co-signer, if you will. That's different from Jewish law. So right there we have to understand how much further ahead in terms of legal rights, in terms of civil rights, Jewish law and the Torah has been for women in comparison to secular situation. Okay. She can acquire property. Again, a right that secular women did not have until the last century or two, because it depends on which country you're talking about. She can acquire property, and we know this because in the poem that we read and studied that Shlomo HaMelech, King Solomon, wrote about his mother Bathsheba, which we know as Eshes Chayil, right, which we did study. In that poem, one of the praises of a woman that Shlomo is talking about mentions acquiring land, right? She sees a parcel of land, she envisions it, she buys it. All right, that's one of her praises, is that she's an amazing, astute businesswoman. She knows she can envision, meaning she can see into the future. She can see a plot of land and say, wow, this would make a great vineyard, or this would make a great, hotel, the area for hotel, and I'm going to build it, and that's one of the praises that Shlomo gives to her. She can acquire property and dispose of property. Okay. She can be a litigant in all cases of contracts and damages. She can sue someone. Okay, not a problem. Okay. She can be sued. So if she owns a piece of land and her neighbor, who's a man, has an issue with a tree she's planting, or a building she's putting up that blocks his view of the river, right, she can be sued. Okay. Typically, we should understand, though, that a woman, when she gets married, arranges things so that the husband is the financial overseer of her business. But that is not something that has to be done. In other words, she has a choice. When she enters into a marriage, she has the choice to sort of relegate, financial responsibilities to her husband, or not. and you know, she can choose to be the disposer of her wealth and what she does with that money. I mean, in marriages, we know anyway, the woman is the one holding the purse strings, right? Even if the man is the one who owns all the property, the woman is really the one controlling it. So that's not really an issue. It's not a problem at all. Okay. And finally, I'm going to go back to the Gemara now. That continues to talk about the verses from the Torah and how they relate to women under the law. The final one that they mention is, and the verse, and he killed a man or woman. Okay, so the verse from the Torah is, and he killed a man or woman. And the Gemara explains, teaches that men and women are equal as far as deaths are concerned. So in other words, a woman as a victim, right? This the first verse sort of was the opposite. The woman as the perpetrator, she's equal under the law. This is a woman as a victim, God forbid, equal under the law as well. Okay, so if she's a victim of a crime, you cannot say that she, as they do in certain under Sharia law, for example, that a woman has fewer rights under the law. She is at the mercy of her father, her husband, or even her brother. So again, we're seeing that in general, when it comes to women and the law are equal. Okay. Now let's get to the topic of inheritance. Okay. Feminists love to point to this fact that Jewish women are not entitled to an inheritance of their father's property. That's when I say it like that, it's kind of shocking. Women do not get an inheritance, right? They're not. If, in other words, if a man dies intestate without a will, he has no plans, then the sons will inherit the property and the money, or the business, whatever it is that he's left. The girls in the family do not get that. Do not inherit any piece of it. Now, on the surface, that seems shocking, and it's a favorite topic for women who have a beef with Jewish law as being misogynist. They love to say, see, this is proof that the Torah or rabbis have a bias against women. Right? How are you going to argue about that? How are you going to argue that one, right? It's kind of, on the surface, it looks hard to argue.
You're smiling. So
I am smiling for a good reason. The fact of the matter is, the laws are one-sided. But we're going to see they're actually one-sided in favor of women, in favor of the widow, and in favor of the daughters. Now, you're still pretty doubtful. Wait, it gets better. Okay, so I'm gonna give away a spoiler. Okay, I'm gonna give away a spoiler. I'm gonna tell you the punchline, really, or the sort of the basis on which all of this explanation lies. And this is the reason that it's in favor of the women, and actually the laws reflect the needs, the actual real needs of the widow and the daughter. So the reason that I'm saying that is that in Jewish law, okay, the heirs to a man's estate have to be put aside until creditors are satisfied. In other words, and that I think this is pretty. This is also the case in secular law. In other words,
I handled my parents' estate, and that is accurate. The creditors get what they get before.
That's right. Right. So if there is if there's a lien on that estate, if the man dies with $20,000 in credit card debt, all right, and there's an heir or two or three, the credit card company must be paid, right, before the heirs can get their section of money, their amount of money. Okay, now, what this means is, I'm going to, again, give away the punchline here. The wife and the daughters in Jewish law have the status of creditors rather than heirs. They are not heirs. They become creditors of their father's estate, and I will explain how. So basically what that means is they're going to have a lien on all the property, which is going to supersede the right or rights of the heirs. Okay, now we're going to explain how. So first of all, understand that the law of inheritance goes to the son applies only that the property goes to the son. This applies only if the father dies intestate, without a will, right? Okay, now there's really no such thing as a will. I mean, in Jewish law, you can set up a will indicating such and such property goes to this person, such and such property goes to that person. However, because women don't inherit, they're not heirs to the property, the father cannot stipulate in the will anything that would go against that, anything that would go against Jewish law. So the father cannot say, I want all my property to go to my daughter. That will not happen. Because you can't contradict the Jewish law, and the Jewish law says that daughters are not going to be heirs. Okay? Okay. But let's keep something else in mind here. He can give a gift of his property to his daughters and give a gift of his property to anybody that he wants to, right? So before he dies, he can say, I want my whole household to be given to my youngest daughter, whom I love best, all right? He can do that, okay? He can give a gift of what. Now, there are some restrictions on this gift-giving idea that I'm going to talk about later. And again, the restrictions favor the women. Okay, you're going to see how. Okay, so that's the idea that if he leaves a will, he can leave a will. He can make a gift of his property to become effective upon his death. He can leave his property to anybody he wishes before his death. However, again, there are some restrictions which we will go through later. Okay.
I'm sorry.
Yes.
Could you repeat that again? He can't will anything to his daughters, but he can give it to them before he dies. And then you said one other thing.
He cannot make a will that will contradict Jewish law. And Jewish law says the daughters will not be heirs. So he can't stipulate that my eldest daughter is my first heir. And therefore she will get the property, right? She can't be an heir, she can't inherit the property. However, he can say, I give a gift of $20,000 to my eldest daughter, and I give a gift of $10,000 to my second daughter. He can give away his television, his VCR, his car. In his will, he can do that. He can make gifts, saying that upon my death, my Maserati goes to my fourth grandchild, if you want.
And he can also give gifts to his sons. This is the same process?
No. That's where the restrictions lie.
Okay.
He cannot make. I guess I'll give away the answer at this point since you asked. He cannot give unlimited numbers of gifts to the sons. This is how the daughters have the advantage. Because again, we're going to see that they are actually creditors.
Is that a semantic way of getting around the law?
No.
By saying it's a gift rather than an inheritance?
Well, halakhically, I mean, legally, what we're talking about when we say inheritance is all of his earthly goods, right? All of his earthly wealth. So in other words, what's rightly coming to the son is everything left over of all the property after the creditors are taken care of, right? So that's different from saying I'm giving a gift of X amount of money to my daughter. Again, he's not able to say, my daughter is going to inherit. She's my heir, and she will inherit all of my property after the creditors. It is a little bit of a different semantics, but it doesn't circumvent the law at all. It doesn't circumvent the law at all. Let me explain a little bit more, and if you still have that same question afterwards, we can get back to it. Let me explain a little bit more. Okay?
Sure.
Maybe the question will be cleared up. Okay. Now let's talk about the details of how this works. Okay. So we talked about the ksuba, the marriage contract, right? In good length in a few classes back last year. We talked about the ksuba. The ksuba, the marriage contract, is a document that is set up, the sole purpose of it is to enumerate the responsibilities and obligations that the husband has towards the wife. That's okay. It's all right. That the obligations that the husband has towards the wife. That's all right. Put it under a pillow or something. The husband has obligations of financial support towards the wife, and physical support towards the wife, and as well as emotional and needs of intimacy as well. We discussed that at length. One of the things that the ksuba is set up to do is to ensure that after either death of the man or divorce, that the wife is also going to be taken care of. Okay, we discussed how difficult it is for a man to actually divorce his wife because financially, basically, the terms of the contract, the marriage contract, stipulate that he has to support her for a full year on his full salary. He gives basically a full year's salary. It's very difficult to financially for a man to support to get a divorce, and it's set up that way specifically, so it shouldn't be an easy thing. Now, in the case of death, the ksuba also stipulates what the woman is going to be entitled to. This is her financial protection. This is her financial. This is her IRA. This is the Jewish IRA. Okay. So the ksuba provides for the wife and daughters after the husband's death. Now, what are these benefits? So the rights that are granted from the ksuba is either the wife actually has a choice. After the man dies, she can get a lump sum payment, right? Or she can get continual support from the estate. Okay. If she takes a lump sum payment, by the way, all right, her support if she takes a lump sum payment, that's it. She's not entitled to any other money the rest of her life. If she remarries, the support also stops because it is presumed that her new husband is going to take on that support. Okay. If she chooses continual support, right? If she chooses the other option of I'm going to live and get supported from the estate, then the estate is required to support her. So all the money that the husband had is now funneled into supporting the wife. She's entitled to keep living in the house. Okay. She's entitled to keep running the businesses. She's entitled to living in the manner that she was accustomed to, or the manner that her husband was accustomed to, whichever is greater. All right. So the son cannot decide to put her on bread and water. He is responsible. The estate is responsible to support her in the manner that she was accustomed to. If she got a gift of new jewelry every year from her husband as a rote thing, and she gets her diamond necklace.
That estate was sizable enough and well managed.
Right. Well, exactly, of course. This system, though, you're going to see in a few minutes, the system is actually more beneficial if there was a small estate. And you'll see I'll explain what that means. It's not beneficial for her, but the system of creditor versus heir. We'll see in a minute. So again, she has to have all her household needs fulfilled, her personal needs, food, clothing, use of the home, everything. She gets everything. All right. If she remarries, she doesn't get any support. If she takes a lump sum, she gets no support. Okay. And the lump sum settlement is something that is an amount that is specified in the ksuba, and usually with a legal minimum. You can't have less. She's not going to get less than this amount. Okay. Now, let's talk about so that's the wife. The wife is supported on the husband's estate. Let's talk about the daughters. Okay, so what about the daughters, right? So the wife is taken care of. Now again, remember, if there is a small estate, if there's a big estate, the wife is going to be supported. Okay, let's talk about the daughters. The daughters are also given the use of the home, assuming they live in the house until they marry. The ksuba also stipulates an amount for the daughters' dowries. Right?
Then a terrorist doesn't wipe us out, okay? When you're ready to leave, one little prayer that we shouldn't get wiped out by a terrorist in New York. Okay?
Got it.
That you will have safety and health in all ways. That everyone will be safe and healthy in all ways.
Does she need us to leave? Does she need us to leave now?
No.
Okay.
Well, that's
okay. Back to the daughters. The daughter's dowry is stipulated in the ksuba as well. So in other words, the husband dies, the wife is living in the estate, the daughters are still single. There is dowry money that they are entitled to upon their marriage. Okay, and again, this will take precedence over any son's inheritance. This is going to come first. Okay. So basically this means that the entire estate is frozen by the women. The women get the use of any property first, right? Okay. Any property that remains after satisfying the support of the women, the wife and the daughters, then that is under discussion as inheritance money for the sons. Okay. Now, again, it seems a little bit unfair, but let's discuss what this really means. The heir, as I said before, an heir, a son who is an heir, has no lien on his father's property, right? Which means what? He has no, first of all, he has no rights to the property during the father's lifetime. All right. The inheritance is what is called by the law davar shelo ba la'olam. It's something that hasn't come into existence yet. It's a theoretical inheritance, right? Father dies. The mother, the widow is left with, I don't know, 3 girls and 1 son. All right. The son has a hands-off rule to that money until the wife is taken care of. In other words, till her death, basically, I think. The daughters need a dowry from that same estate. The son has no rights to any of it until that is all satisfied. Okay. So he can only take what remains of the estate at the time of death, and his share, by the way, let's talk about this. Okay, this is you're going to like this one. His share of inheritance is, of course, liable to any creditors, right? We're going to talk about the daughters and the wife. The daughters and the wife are not heirs, as we said. They are creditors of the estate, meaning they have a lien on all of the father's property, including what he owned, before his marriage. So they have now, let's say you have 2 creditors. Let's say in secular law you have 2 creditors to one estate, right? I'm not sure this is the way it works in secular law, but it might as well work that way. It could. I don't know. If you have 2 creditors in Jewish law, you have a credit card company, Jewish-owned guy gives a credit card to someone. You have a $20,000 credit card outstanding bill, and you have Mr. Smith who loaned you $10,000. So now the man dies. So now he owes $30,000. Right? One is a $20,000 credit card bill, and the other is a $10,000 personal loan. Okay. Who gets paid first? Let's say the estate is too small. Who gets paid first in this situation? I'm not even bringing in the wife and the daughters. I'm saying in general, if you have 2 creditors, in Jewish law, it would be the one who had the prior ownership. In other words, who came first? Who gave the debt first? So if Mr. Smith gave his loan to the father first, he gets paid first. Mm-hmm. And if the credit card loan came first, then the credit card company gets paid first. Okay? Mm-hmm. Okay. Listen carefully. The wife and the daughters of a man's estate are considered the first creditors. Okay. Meaning that if you have Mr. Smith who gave a loan of $10,000 to the father, and you have a loan of the $20,000 from the credit card company bill, and you have the wife and daughters, the wife and daughters are going to be paid first. They are the first creditors. So the wife precedes all creditors subsequent to the marriage. Okay? Therefore, their rights precede not only the heir's rights to the money, but also any other creditors.
How can these, so-called feminists get it so wrong. They're so incredibly ignorant.
Well, first of all, because they pick and choose what they want to understand about the laws. They pick and choose what they want to know.
Ask an Orthodox rabbi?
I doubt it. I doubt it.
Actually,
I doubt it.
do want to stand up in some way. There are feminists who just have bones to pick and axes to grind, and I could use other metaphors also, but a lot of also things were not really out there. There were many issues that I did ask about when I was not in this community. I was in my 30s, and I would ask rabbis, and they didn't always really know. So there were, and then there are a lot
Orthodox rabbis?
Yes, Orthodox rabbis. No, I wouldn't. I don't recall asking a Reform rabbi about anything. And a conservative rabbi, I wouldn't expect would know Orthodox law. So Jewish law is very complex, and not every rabbi is well versed in every area. But I think there are. This is the first I've heard of a lot of this material,
right.
And it's not like I have had no interest at all in women and inheritance.
Right.
The information I didn't know where to really get.
Right. And the other thing is that, again, the what we call pshat, which is the plain textual reading, right? It can't be, the Torah cannot be understood with just the textual reading.
Yeah,
it can't be understood.
I learned my lesson that way.
Hmm?
I learned my lesson that way. It often means the opposite of what it says.
Times it does, yes.
And so
that's right.
My assumption is if it sounds horrible, it probably isn't.
Right.
Even if I don't know the
reason
yet.
Right. So a lot of times people will just look at people who are not schooled, and I'm not even talking about scholars. I'm talking about people who don't get that you need the accompanying oral law, the rabbi's explanations, in order to understand it. But you also, even if you do understand that, that the text, the Torah's text has to be explicated via the rabbi's words, you may understand that and accept it, but then you don't. But then you may not accept the fact that what the rabbis have to say is valid because you view the rabbis as misogynistic and making up their own laws. We, however, have the philosophy and we have the acceptance of the fact that the oral laws were given to Moshe, at the same time that the written laws were given as a way of explicating them. And therefore, what they have to say about the subject matter is as divinely inspired, if not outright given, to us. Right. So other people do not. People who are not Orthodox typically do not have that philosophical a priori position, right? Where if they accept at all the Torah is from Hashem, which they don't necessarily, but even if they do, they're much less likely to believe that the rabbinical writings were also concomitantly given. And so therein lies the problem. Therein lies the problem. Yeah. So you know what I mean. It's difficult.
Yeah, I hear what you're saying.
Okay.
Submission is a very tricky thing. Please go on.
Okay. Let's continue. So that's how they are. They're actually given the edge when it comes to inheritance, because again, the son cannot touch any money till the creditors are taken care of. The wife and the daughters being creditors, they're taken care of first. They're taken care of first, and they are guaranteed support if there is any money left over. Now, it's interesting. Okay, now let's understand a couple more things. Furthermore, in addition to all this, as we said before in the beginning, the father can give the daughters any gift that he wants to give them, right? We said that. He can even give them a portion of the estate. This is called Shtar Chetzi Zachar, and it's mentioned in the Shulchan Aruch. But, and of course the son, right, who doesn't have any liens on the property, has no say in this. You can argue, Dad, what are you giving here? But they have no legal say in this, right? On the other hand, the lien that the wife and the daughter have means that the father cannot make a gift to the sons in any amount. Right? He cannot, in other words, let's say the entire estate has $100,000, and the support of the wife and the dowry of the daughters would take up, let's say $50,000. The father cannot say, I'm giving you, my son, before my death, I'm giving you $60,000, because that cuts into what he's going to owe his wife and daughters. So he is restricted from giving a gift of money or property to not only his sons, but anybody else he wants to. Let's say he doesn't like his kids and his wife, right? He doesn't like his kids and his wife, so I'm sure this happens in secular law all the time, and you want to really dig.
Leaving it all to my cat.
Yeah, leaving it all to my cat, exactly. Leaving it all to my cat. I'm leaving it all to, Leona Helmsley did that. She left it all to her dog. I can't remember if it was a dog or a cat. And just by, this kid didn't get anything, that kid didn't. You can't do that. The father cannot do that because he is limited by what that kasupa, what the marriage contract to his wife states. It restricts him in terms of what he's allowed to give. He cannot overgive anything that would eat into the estate that is going to go to the support of the wife and the daughter. So he's limited in terms of gift giving. Yeah.
Would that also include, let's say the wife and daughters will need $50,000 and he also owes $10,000 to a credit card company. Can he give money that would cut into the credit card company's share or not?
I don't know the actual answer to that, but given the fact that we've established that the wife and the daughters are the first creditors and the first creditors are paid first, so the answer I think would be yes.
Okay.
That the money goes to the wife and daughters even at the expense of the second creditor, because we're saying, in other words.
But I mean, he couldn't, okay.
Yes.
Go on.
I think that the answer is yes.
I'm going to have other questions that I want to know even more. But
okay. I think the answer to that is yes. The first creditor means that you have the rights first to the money. And if there's a deficit, too bad, on the second creditor.
Okay.
So yes, the wife and daughters are the first creditor. The wife is the first creditor. Okay. So now the daughters are also given a dowry, right? That's going to facilitate their getting married, facilitate marriage. Again, this is, all of this system was set up to protect the women of the family. So therefore, again, in the kasuba, in the marriage contract, it stipulates not only what the husband is going to owe the wife, but also what he's going to owe his daughters. All right, it's stipulated there as well. Okay, the Talmud says if the estate is small in regards to inheritance, if the estate is small, the daughters are supported and the sons go begging from door to door. Okay, now. Why is that? It means that their support is guaranteed, right? And they precede the sons, as we said, because the sons don't have a lien. The creditors have a lien, right? Okay. Mm-hmm. So while they don't get a share of the inheritance, we see now how it is much more to their benefit if they are not inheritors, but rather creditors to the estate. This is more, they are more protected in the crucial case of there being a small estate, right? Because if there's a small estate, if there's no money left over after the daughters are satisfied, the sons are out of luck, by the way. That's it. Like I said, if there's two creditors to the estate and the money is used up paying off the first creditor, i.e. the wife and the daughters, the second creditor is out of luck. Well, if the second creditor is out of luck, the son's out of luck too. Okay, so therefore, you can see that the logic of this system is that the son, again, keep in mind that in ancient times it was much more likely that a man would have a better, an easier time of making a living than a woman would. I would presume that a woman would be more limited in making a living for numerous reasons. Okay, so therefore, it is set up in such a way. This has been set up in such a way that the women are absolutely supported. They don't have to scramble to try to find a job, assuming there is money in the estate to support them. And it is the job of the sons who have to, as the Talmud says, go begging from door to door. The women are supported, and the boys have to do the work. So we see that there is really, and this really does support them better in case there is a small estate. right? Okay. So, in a dispute between the heirs and the women, halacha is usually going to decide in favor of the women. Now, there's one other thing we have to discuss, and that is the fact that women do not inherit land. Now, again, the land that we're talking about is in Eretz Yisrael, is in Israel, right? We're not talking about land outside.
Only in Israel.
Yes, we're talking about the fact that women are not allowed to inherit the land of Israel, okay? So what does that mean? Why? So in other words, so why is that? Let's see. It is a very logical explanation. Logical in the sense of what would be best for the people of Israel. Okay, so a woman can marry a man, any man of her choosing. Could be a man from in her tribe or outside her tribe. Remember that there were 12 tribes originally that settled the land, and each tribe of Israel got a separate parcel of the land. This was, right, Reuven, not Reuven, but, Levi didn't get a parcel either, right? But the tribes each got a piece of the land. Okay, so what would happen if a woman married, she was from the tribe of Binyamin and she married someone from the tribe of Shimon, okay? So her son is a member of the tribe of Shimon because the allegiance to the tribe goes paternalistically. When it comes to the identity of a Jew, it's a maternal inheritance, right? The boy is Jewish by virtue of having been born to a Jewish mother, but the boy is now a member of the tribe of Shimon, having been born to a father of the tribe of Shimon. Okay, So what happens if you're allowed to have intermarriage between tribes, but also were able to have let's say the women inheriting the land. So let's say this woman who married, she's from the tribe of, Binyamin, and he's from the tribe of Shimon. Okay, they have a son who's now Shimon tribe, in the Shimon tribe. She had a father who left her land. If that were possible, halachically, if she was allowed to inherit land, her land would now transfer over, right, to Shimon upon her marriage, which is what happens financially to a woman when she marries, assuming she doesn't make alternate accommodations, then the husband sort of acquires her property as well, right? So now we have land that did belong to Binyamin going to Shimon. Right? So it's getting a little confusing, right? Mm-hmm. Okay, and now let's say the son of the Shimonite, son marries someone from Gad. Okay, that property of land, which was originally Binyamin's, then went to Shimon. Right? Well, it stays in Shimon's tribe because of the woman. But let's say there's a daughter. The second daughter inherits some land. Okay, and she marries someone from the tribe of Gad. Okay, and so now that property is in Gad's tribal possession. So there's a little bit too much confusion. So you would have after a while you would have no distinct tribes. You would have no distinct areas of tribes. Okay. The other possibility is that you don't allow for intermarriage between tribes, and that's just not right. That's not fair. We want to allow people to marry, right? They're bashert. They're bashert maybe from another tribe. They're intended maybe from another tribe. So as a compromise, as a way of saying we're going to allow intermarriage between tribes, but at the same time we're not going to, because if you don't allow intermarriage between tribes, what you'll end up having is 12 separate countries, 12 separate nations. And you don't want that either. Right. You want to have one nation of the Jewish people, but at the same time, you don't want to have Hefker Welt, where you have the property belonging to everyone and therefore no one. Mm-hmm. Right? You wanted to have distinct tribes. So this was a compromise by saying the woman can intermarry into another tribe, but the property has to stay in the original tribe. And that's the reason that she can't inherit land.
Does that still work in Israel today?
Does that law pertain? Is that what you mean? Yeah. Does that law pertain?
Right, because we don't have the tribal system.
Because that might have gone the way of
Once the Northern Kingdom and all those
exactly right.
Disappeared.
I'm not sure. It's a good question.
Yeah, but
try to find an answer to that.
What Miriam says makes sense. You can't really identify which land
tribes
belongs to which tribe.
Well, that's true. We don't have that identity of this being
We don't have
right.
all of that land anyway. Part of it belongs right now to the country of Jordan, I think.
Well, now we're getting into political discussions, but
I mean, just
right.
Right, it really all belongs to Hashem. We know that, but
no, but Hashem did allow us to have ownership in pieces that we buy. Yes,
ownership
right.
of it at this time.
Yeah, but again, it's not a tribal issue anymore because we don't have distinct tribes.
Right.
We don't even know which tribes we come from unless you're a Levi. Then you do know, but other than that, you're not sure.
Or a Kohen, right?
Kohen or Levi is from the tribe of Levi.
Right.
But because there's no tribal identity anymore, then the tribal issue is gone. But does the law, is there a remnant of that law having to do with leaving land to daughters? That's an interesting question. I don't know the answer to that. Okay, so that's basically it. Do we have any questions as follow-ups, or you want to delve deeper into something?
Yes.
Okay, Miriam, go right ahead.
Okay. Let's say it's in America, to make things simple. A man marries and has daughters, and then his wife passes away, and some of the daughters get married and some of them are not yet married. Then the man wants to remarry. What are the rights of the new wife versus the unmarried daughters, or versus do the married daughters are they creditors or are they not creditors? And what about
the married daughters are not any longer creditors because they've been their needs have been satisfied with the dowry. And once they're married, that obligation of the father is fulfilled.
And what about the unmarried daughters?
I think they still do have
creditors in the second wife?
Yes, I think so. I believe so.
Okay.
Yes.
So
they're first creditors. Yeah.
What if the unmarried daughters? I mean, weddings are not cheap these days. What if they are not satisfied with let's say a $2,000 wedding? Does that mean that the new wife has to say, well,
No. The obligation of the father is not to marry his daughter. It's just to give a certain monetary amount. Now, the daughter can choose to make a lavish $100,000 wedding with that money, assuming that that's the amount he gives her, or she can choose to have a very small, modest wedding, which it is possible to do. Nothing is required other than having 2 witnesses at a wedding, and a ksuba and the ring, and that's it. Nothing else is required, and a little wine for the brachos under the chuppah, and sheva brach, and a little a meal, a simcha, a suda simcha, a meal of joy, and of course, and having the right. So a little challah, a little piece of my grandparents when they got married in America in the 30s, they had salami sandwiches. And that was their wedding meal. And that was it. It was a very, it was small affair. It wasn't, So the obligation, again, is the dowry. The point is that the obligation requires the father to ensure that the daughters have what they need to make it into the next stage of their life, meaning marriage. And that would ensure that they would be more attractive to a potential husband.
What if one of the daughters doesn't ever get married? Is the father always obligated in her support?
Yes. Okay. Yeah, the obligation of the daughter's support is stipulated in the marriage contract of the mother, or the dowry is. I'm not sure if the actual day-to-day living of support is ensured in the ksuba. I'm not sure about that, but the assumption is the daughters are going to be supported by the same estate that supports their mother.
Okay.
Yeah.
What if the facts are the same, except instead of the first wife dying, they're divorced? The man is obligated to the first wife, who is, if she does not remarry. And
no, he's not obligated. No, the obligation in case of divorce is a specific lump sum that's specified in the ksuba, in the marriage contract. In other words, the marriage contract says, this is what I owe you during marriage, and this is what I owe you in the case of divorce. And it's usually approximately 1 year's salary for the man, whatever he's making, which is a tremendous amount of money, right? It's a lot of money. But it doesn't stipulate that he's required to support her after that lump sum. And she doesn't have the choice of the lump sum and the continual support as she has in case of widowhood.
So the first wife's only choice is
a lump sum.
A 1 year lump sum.
That's correct.
Okay.
And she doesn't really have she can refuse it if she wants, but
pull that much money together.
Exactly.
And then that's it.
That's it. That's it for her. I don't know about the daughters, if they are taken care of in that case of divorce as well.
Yeah, like
I'm not sure.
Support.
Child support.
Well, if they're grown, I mean, if they were underage, I would.
No, I'm saying in terms of a dowry.
Yeah.
I'm thinking in terms of dowry. I'm not sure. I would think so. I would think that he's still obligated to their dowry, no matter what happens to if she dies or if there's divorce. He would still be obligated, I believe. Yeah.
Okay. So, if a woman marries a divorced man, she happens to have property. She happens to have money or racehorses, whatever it is she in any way obligated to the unmarried daughters?
It's not a matter of what she's obligated to. Oh, you mean her property?
Her property go to him?
Well,
and then he would pay it out or not? You do understand why I might be interested in these answers.
I understand completely. My exasperation is at my inability to answer your very detailed legal question about because her property. Okay, on marrying this divorced guy.
Yeah.
Or even if he's a widower, right? On marrying him, if there's no other stipulation to the opposite effect, all her property gets transferred to him. All right.
Okay.
And he is acquiring all her property, unless there's a stipulation that she's keeping her businesses separate, her money, and that's fine. In that case, in the case where her property gets transferred to him, does he now have more money with which to support the daughters? Is that what you're saying? So again, the support of the daughters comes before remarriage. In the case of, it's there anyway. Whatever that support is to begin with, it's probably independent of the new wife's property. I don't think that her property has to be, attached. Let's put it that way. But I'm not an expert in this is a very detailed legal question, and I don't know definitively the answer to that.
Well, if the woman comes into the marriage with, a lot of holdings, and there's a divorce, and she didn't have a prior prenup contract, then she's only entitled to 1 year's worth of income, then he would end up